Okay, very good morning, all CA Foundation students. The law answer writing series this is the part 3-1. Okay, previously I had discussed few questions related to Indian Contract Act. Now let us look at Sale of Goods Act. Okay, so my objective of revising these few questions is basically to tell you how to actually approach answer writing in business law, CA Foundation, right? Okay. Sale of Goods Act, you have got four important concepts. One is a contract of sale, sale and agreement sale, difference. And the next one you have conditions and warranties. Then we have transfer of property. Then we have uh, third party transferring ownership, auction sale, small concept we have. Okay, so definitely, as I told you, from sale of goods also almost around 20 questions, 20 marks worth questions you have in CA Foundation. So be very careful. So make sure you don't ignore these uh, concepts. Okay, as I told you earlier, Contract Act and sale of goods and company law, these are technically interesting, easy, plus at the same time they're scoring. So almost 70 marks worth are coming from these three chapters only. So make sure you focus on these three chapters and revise more number of times. My only objective here is to tell you that this is how exactly you have to approach answer writing. But what you are supposed to do, you make sure that you practice. A lot of practice is very important. Okay, otherwise it's not possible. All right. Prakash reaches a sweet shop and asks for 1 kg burfi if the sweets are fresh. He's asking fresh sweets. Yeah, just a second, please. Okay, fresh sweets he wants. Seller replies, sir, my all sweets are fresh and of good quality. Prakash agrees to buy on the condition that first he tastes one piece of burfi to check the quality. The seller gives him one piece. So this is where in sale of goods you need to understand there is a sample given. Good, got it now. So when the sample is given, when the description is given, when the goods are delivered, the goods which are delivered must be matching with sample description that is given. That is the concept, right? The seller gives him a piece to taste. Prakash, on finding the quality is very good, asks the seller to pack. Okay. On reaching the house, Prakash finds burfi is stale, outdated, and not fresh, while the piece tasted was fresh. The piece which was given to him was fresh, it seems, but the sweets which are delivered to him are not actually fresh. Now Prakash wants to avoid the contract and return the burfi to seller. So what is the concept in this? Concept is very simple. Concept is very simple. When the sample implied conditions, implied warranties, bulky one concept is there in sale of goods. Yes or no? So conditions are basically essential to the main purpose of the contract. Warranty is collateral to the main purpose of the contract, the concept, right? So the conditions and warranties are basically stipulations. These stipulations can be express or implied. Implied in the sense their seller need not say, but seller has to follow those things. It is implied by law. And when the seller has given a description, when the seller, one of the very important condition, implied condition is that when the seller has given sample, when the seller has given description, the goods which are delivered to buyer should match with sample and description. That is the concept. So this is basically what, if in case a seller at the time of selling the goods has given any description or sample, bulk of the goods after delivery should be matching with the sample that has been shown. So in this example, the sample sweet is already given, that was fresh, no doubt about it. So the remaining sweets which are delivered to the customer should also be matching with the same thing. Bulk, a substantial portion of the sweets which are delivered should be matching with the sample that is given. Yes or no? Hmm? So that is the concept. So basically concept you have to explain first paragraph I said, see there, as per section 17, in case contract of sale by sample, the implied condition is that bulk must correspond with the sample in quality. And also buyer shall have a reasonable opportunity to compare the quality. And according to section 15, where there is a contract of sale of goods of description, there is an implied condition that, so indirectly this section 17 talks about two very important things. 17 and 15. When the seller has given a sample, the goods which are delivered to buyer should be matching with the sample. When the seller has given a description, there is an implied condition that the goods which are delivered must be matching with described goods. This is the concept. So first paragraph we finished explaining concept. Then in the case, what happened actually? The sample which is given is not matching with the goods which are given. So therefore, first question is what? State with the reason whether Prakash can avoid the contract. It says in the given case, sale of sweet is by sample, quality bulk does not match. So Prakash can return the sweets and avoid the contract and take his money refund. So that means your 60 to 70% of the question is completely in the name of concept. So first paragraph, this is what you don't simply go by your own conclusions and answers. Please try to first go by the order pattern you follow. The second question is, will your answer be different if Prakash doesn't taste the sweets? In other case, sale of sweet is the case of sale by description, and the quality of good does not correspond to the description. He also said, no, my sweets are fresh. He gave a description. No, if the sweets are, so that means one side he gave a sample. On the other side, he also gave a description. No, my sweets are always fresh. So therefore, even in that case, he can definitely, if in case the sweets which are delivered are not matching with the description, buyer can definitely return the goods, avoid the contract, and cancel the contract, take his refund, and go off. That's it. Got it now? Quickly move on to the next question. Akansh purchased a television set from Arvind, the owner of Gada Electronics, on the condition that the first 3 days he checks its quality, and if satisfied, he will pay for that. Otherwise, he will return the television. So he said very clearly, but first 3 days I will check the quality. If in case it is not okay, I will return. On the second day, television set was spoiled due to an earthquake. Okay. Arvind demands the price of the television set from Akansh. Then whether Akansh is liable to pay the price under the Sale of Goods Act 1930, who will ultimately bear the loss. So what is the concept here involved here? This is called sale and approval. Sometimes the seller must have allowed buyer to take the goods on sale and approval. And sale and approval means what? When buyer intimates that he is willing to take the goods, or when the buyer started using them without intimating, or when the buyer started keeping them even after reasonable time without informing, then we assume sale happened. So the concept is buyer has taken the goods and buyer is supposed to intimate. If in case he did not intimate within reasonable time, then we come to a conclusion that yes, sale happened. Understood? So when the seller delivered goods to buyer on sale or approval or return basis, this is the concept, right? So first one is sale happens when, or property ownership in goods will transfer when. Ownership in goods will transfer when buyer intimates that he has taken the goods. Second one is what? If in case he does anything in the sense if the buyer started using them, if the buyer started reselling them, if the buyer started pledging them, something he's doing without intimating to seller whether he has taken the goods. Third one, he does not signify his approval or acceptance of the goods even after reasonable time. So one is when the goods are given to buyer on sale or return basis, when will you assume sale happened? We assume sale happened under three circumstances. Circumstance number one, when buyer intimates that he bought the goods, that he's taking the goods. Second one, when he started doing something, in the sense he started selling, reselling, or etc. Then third important thing is even after reasonable time he did not inform. Then we understand that the sale happened, ownership is gone to buyer. So whether there's an agreement to sell of specific goods, subsequently the goods without fault of the buyer perish. So here there is an agreement to sell here. Ownership is not gone, no. So there is an agreement to sell. Ownership will be going at a future date. In contract of sale, there are two very important concepts I said. One is sale, where ownership is transferred immediately to the buyer. Second one is agreement to sell, where ownership will be going at a future date. So in this case, ownership will be going only when the buyer intimates or buyer did not intimate within a reasonable time. That means this is a kind of agreement to sell. Understood. So in this case, it says if agreement before sale something happened without the fault of both the buyer and seller, when something happens because of which goods are spoiled or destroyed without the knowledge of both the parties, then it becomes void. It becomes void. Got it? So according to the above provisions, the property is not passed to Akansh. Buyer is no condition satisfied. So risk has not passed to the buyer and the agreement is thereby avoided. Akash is not liable to pay the price because the loss has occurred due to unexpected situations without the control of both the parties. Therefore, the loss finally should be borne by the seller because there was an agreement to sell. Ownership is not gone. That means who took the risk of allowing buyer to take the goods in this regard? Actually seller. So therefore agreement to sell happened. As long as agreement to sell happened, ownership will be going at a future date subject to certain terms and conditions. So ownership has not gone. Since ownership is not gone, definitely we understand that seller has to bear the risk. Yes. I hope I think by now you must have come to a conclusion how to actually answer the questions. All right. Next, move on to the next question. One more question on Sale of Goods Act. Mr. Arun contracted to sell his Swift car to Mr. Nikhil. Both missed to discuss the price. So that means they did not fix the price. This is about fixing of the price. Sale of Goods Act, May first lesson, last 2 pages you'll have. Later, Mr. Arun refused to sell his Swift car to Mr. Nikhil on the ground that the agreement was void, being uncertain about the price. He says that price is not decided, so I have decided not to sell the car. Does Mr. Nikhil have any right against Mr. Arun under the Sale of Goods Act 1930? So my question is regarding price fixing we need to understand. First of all, in sale of goods, what is the consideration? So first paragraph, we are trying to understand price is a consideration that has to be made in money only. And if in case seller agrees, he can make it in partly in cash, partly in kind also. So first one you say consideration in sale of goods is money or price. Next one is the second paragraph. The price of the con may be fixed by left to the fixed by the manner. So there are three important points there if you see. Price can be fixed at the time of contract. First one, price can be fixed in a manner that is decided by both the parties. Third one, price can be fixed over a period of time, over a course of dealings. And fourth one, if the buyer has already accepted the goods, if the buyer has already started using the goods, then reasonable price has to be paid. The manner could be something like third party. They can decide that, okay, boss, let us not fix the price. So let us leave it to third party. An expert will come and fix the price. So there are four options to fix the price. You have to explain them briefly. Even though both the parties missed discussing the price, it will be valid contract rather than uncertain and void. That means because price can be fixed in several ways, right? In the given case, Mr. Arun have entered in the contract of sale, but they did not fix the price. Arun refused to sell the car. Nikhil can legally demand the car. The reason being price can be even reasonable price also. Just because we had an agreement, we did not fix the price. We had an agreement, we did not fix the price. It does not mean contract can be cancelled because there are different ways and methods to fix the price. When there are different ways and methods to fix the price, use those methods now. Use those methods, right? So you cannot cancel the contract. Understood? Now more and more questions you practice from your textbook end of the chapter, plus like this, if you practice, I'm telling you, you'll have a whole similar questions they ask you. Law becomes very easy. So 3-4 days you just focus on reading all these questions, answers, writing answers. At the end of every chapter you have some what you call questions, no practice questions. This will help you a lot. Next one. One more question in sale of goods. Let's say Mr. Shankar sold 1000 kilograms of wheat to Mr. Ganesh on credit of 3 months. So 3 months credit is given. Wheat was to be delivered after 10 days of contract. After 5 days of contract, a friend of Mr. Shankar secretly informed him that Mr. Ganesh may default in payment. Wheat was to be delivered after 10 days. Meanwhile, after 5 days of the contract, friend of Mr. Shankar said he can't pay. So on the information of the friend, Mr. Shankar applied the right of lien and withheld the delivery. I mean, lien in the sense retaining the goods. Referring to the provisions of sale of goods, answer the following questions. First one is state whether Mr. Shankar was right in his decision. What Shankar did here? Shankar did here what? He exercised lien. Lien means what? Retaining the goods. When will you exercise lien? If you go back to rights of unpaid seller, 4th chapter in sale of goods, you have 3 rights of unpaid seller. Who's unpaid seller? The person whose payment has not come or the bill of exchange has been dishonored, etc. So lien can be exercised when the sale happened, means ownership is already transferred, and luckily seller still is in possession of the goods. Sale happened, but the seller still is in possession of the goods. So lien is a retention right of the goods. When the sale happened, then you can retain the delivery of the goods. Okay, next one, what would be your answer if Mr. Ganesh became insolvent in 5 days of the contract? If insolvency is there, yes. So first you have to explain when will you call unpaid seller. Second, you have to explain when will you exercise lien. That's what you have to, right? So this question clearly tells us if in case seller is an unpaid seller, under what circumstances we will treat seller as an unpaid seller. So the second important thing is, if in case seller has become unpaid seller, then what are the rights he has? He has right of lien, right of stoppage, right of resale. But over here, the question is lien. So under what circumstances lien can be exercised? So first point is what? Who's an unpaid seller? The one whose payment has not come, otherwise any negotiable instrument like bill of exchange or check has been given and it is not accepted or dishonored. Next one, it provides that seller's unpaid seller has the, if in case unpaid seller has the possession of the goods, if in case unpaid seller has the possession of the goods, he can exercise right of lien. So the next paragraph you explain concept called, so you see 80% of your question answer is going for concept only. Solution is hardly 20%. You understand now. So the examiner wants you to understand better. Did you understand the concept here? If you have understood concept, please explain the maximum information here about the concept only. So in fourth lesson of sale of goods, we studied that lien can be exercised when the goods are sold on credit term is over. Otherwise, when the goods are sold on cash basis, but cash has not come. Otherwise, seller came to know the buyer has become insolvent. Credit term is over, cash sale, but cash has not come, and buyer became insolvent. Then, if the seller is in possession of the goods, being an unpaid seller, under these three circumstances, he can exercise lien, means he can retain the goods. Understood? So that is the point. It says, in the instant case, Ganesh purchased so and so on 3 months credit. 3 months credit is given already. How can you take a decision after 5? So which was to be delivered after 10 days, but after 5 days, one friend Shankar, Ganesh may default, etc. on defaults. Okay. Then Mr. Shankar applied. So second paragraph, I explained what exactly happened in the case. You understand now, in every case law question, we are trying to explain first paragraph, the concept, and the second paragraph, we are trying to explain what actually happened in the dispute, right? On the basis of above provisions, it can be said even Mr. Ganesh was an unpaid seller until the term credit has expired. Understood? Mr. Shankar had to perform his promise of supplying. So he has to, because 3 months credit is given. No. So when are you supposed to exercise lien? When the credit is given and the term is over. On the second point, you see in that when the term is over, the term is not over. So you have to supply the goods, no option at all. Next one, you see, in case Mr. Ganesh became insolvent, etc., Mr. Shankar had the right to apply for lien, because insolvency is different. So when the credit is given, until the term is expired, you have to wait. No. But before credit term only, you came to know buyer became insolvent. So when the buyer became insolvent, even before the term expired, it is 100% sure that he's not going to make a payment. When he's not going to make a payment, then definitely what you can do, you can exercise lien. So in every question, spend some time to understand what exactly is the concept associated with. Once you know the concept associated with, then first paragraph, always, if you remember the section, start with the section. If you don't remember the section, as per the relevant section of sale of goods. Better to remember some sections, because you are in CA, you have to do hard work, and that amount of hard work, if you don't do, there is no point. All right, that is one thing. So sale of goods questions you just go through, and now what I'm saying, based on this analysis, you also read the questions which are there in the textbook at the end of the chapter. Go through all the questions and you will have some idea. So next video, we will record partnership and LLP together. Okay, have a good day. Take care.